New legislation throughout the world is focusing more on data protection, and consumers now have learned the difference between privacy and security and are ready to hold brands accountable. Today, we're speaking with members of GALA, the Global Advertising Lawyers Association, with member firms in 70 countries. GALA has just released the first ever guide to how privacy laws affect marketing and advertising around the world. Our discussion will start with some details of those privacy laws, then we'll talk more about the issues that will actually affect marketers. There's lots of topics here, so if you find you have some questions on a particular concern, please just let us know, and we'll plan an upcoming talk to be more specifically focused on that issue. 4 members of the GALA team are with us today, and all were involved with creating the guide. I'll let each member introduce themselves and tell us where in the world they're located. So let's start with Daniel.
Hi, Deborah. Thank you so much for having me here today on the show. My name is Daniel Goldberg. I'm an attorney with the law firm Frankfurt, Kernick, Klein & Sells. The firm is a U.S.-based firm, and I'm actually located out in Los Angeles, California. The firm is a member of GALA, as you mentioned, and we were fundamentally part of the process of developing the book, along with everyone else who's on this call today. We're really excited to talk about the book with you today and share takeaways as well as information just generally around privacy and data security law, which is particularly my area of focus, especially in the advertising and ad tech context. So thank you again.
Great. All right. Well, how about we move now to Soren, who's in Germany. How about you give us a little background on yourself, Soren?
Well, thank you, Deborah. I'm a partner with the German law firm of Heuking Kühnlüher Wojtek since the year 2002. Working out of our Hamburg office, I'm in charge of the advertising law and trademark law department. And as a member of our firm's data protection task force, I also work on data privacy matters, especially relating to advertising issues. Our firm is the exclusive member of the Global Advertising Lawyers Alliance, GALA, for Germany, and I currently serve as GALA's EMEA regional president and member of the executive committee.
Well, thank you. That's a lot of quick information. Now let's go to another part of Europe, the UK. So Bryony, let's hear from you for a minute.
Hi there, Deborah. My name is Bryony Long. I am a partner in a firm called Lewis Silkin, which is a GALA member firm. I head up the data and protection practice at Lewis Silkin. I specialise in all different areas of data protection, but particularly in advertising and marketing context. Me and my team helped write the UK chapter of the GALA book and look forward to sharing some more thoughts with you today.
Great, that's wonderful. And last but certainly not least is Oscar in South America, and I believe in Chile.
Exactly. Thank you, Deborah, and thank you all for having me today. I'm also very excited to talk to you about privacy. As Deborah anticipated, I'm an attorney. I'm also a certified information privacy manager, certified by the International Association of Privacy Professionals, and I lead the privacy practice in Albagli Saliasnik, AC for short. We're a full-service firm based in Santiago, Chile, but today I will be talking about the reality of privacy and marketing from a South American perspective for the entire region. Thank you.
Well, great. Well, why don't we open it up right away? I did mention that we would start with some of the specifics about the legal aspects of this before we jump into the more theoretical issues for marketers. But since each of you worked on a chapter in the book regarding privacy laws and regulations in your own particular jurisdiction, why don't you each tell us a little bit about the laws in your own area, in your own regional area for this data issue? Daniel, let's start with you in the U.S. You are in California, and I know there's a lot going on there.
That's exactly right. There's a lot going on under the U.S. With respect to privacy and data security. So, interestingly, unlike other jurisdictions, which Bryony and Soren will talk about, specifically Europe, we don't have a comprehensive federal level privacy law here. U.S. privacy law is generally regulated from a sectoral perspective, meaning that different types of data sets are governed by specific laws. So children's information, you have regulated by COPPA, health information in certain respects, so certain types of entities and healthcare providers would be under HIPAA. You have other types of data like financial information, sensitive information. So those laws at a federal level regulate these types of data, but we don't really have a comprehensive law. There have been efforts at a federal level to get something passed, but so far that hasn't panned out. What we do have, however, is we have state laws, state regulations. So on the data breach side, every state in the United States has a data breach law. And now we have this new, very comprehensive state law from California, which went into effect at the beginning of this year in January 2020, and actually started being enforced, or at least was eligible for enforcement starting at the beginning of July, so just 2 weeks ago, called the California Consumer Privacy Act, the CCPA. And the CCPA is similar in a lot of respects to the GDPR, which again, we'll talk about in a bit, but just some highlights around the CCPA. It gives residents of California certain types of rights with respect to their data, the right to know information around their data, as well as the right to delete their data. It also has obligations which could very much affect the marketing and advertising segments and have affected it. So this obligation called Do Not Sell My Information, and I'll talk a little about that as well. And then other obligations as well around notice and other types of choice. So again, a very important law for marketers and advertisers to understand what the implications are with respect to the law.
Yes, particularly, and I'm sure we'll touch on it later, what that might mean to other states in the Union. You mentioned GDPR, so why don't we go to Germany now with Soren, and maybe you can give us a little bit of an update on that. That's now been in effect for over a year, correct?
Well, Deborah, actually, it's been 2 years now that the GDPR came into force in May 2018. The GDPR applies directly in all member states of the EU, and that includes, of course, Germany, and has led to quite an awakening in Germany and elsewhere. Since then, companies were furiously working on both ends to comply with their new privacy obligations. Their front end, which I would call the privacy policy that needs to be in place on all website and points of sales where personal data are collected, and their back end, which refers, for instance, to the records of processing activities, to the data protection impact assessment, to the technical and organizational measures to ensure compliance with data processing under GDPR, to concluding either a processor agreement or an agreement of joint controllers, or to appointing a DPO. This all needs to be in place. But not only the processors had to make up for the past, but also the authorities began to issue guidelines for each of the topics addressed in the GDPR, especially helpful in Germany, were the guidelines of the German Data Protection Conference, which is a conference of all 16 German state data protection authorities, and they issued guidelines reflecting their common understanding of the requirements and interpretation of the GDPR. The courts, however, might rule differently, but as a start, this was very helpful, as a processor in particular state could at least point out to the competent authority that he complied with what the conference had suggested. In addition, GDPR left room for specific national legislation. Based on the so-called opening clauses in the GDPR, the national legislator was allowed to regulate certain areas of the law which the EU deemed more appropriate to be handled by the individual member state rather than in a supranational manner. One good example here is the regulation of labor law issues, which was totally left to the member states. So most, if not all, of the EU member states have meanwhile issued specific national laws on certain topics. But this does, of course, not mean that the legislation has come to a halt. Well, I should perhaps say, you know the Germans. If there is something to regulate, they are on it, and so we will certainly see amendments of the federal law making use of some more of the opening clauses.
Well, it's interesting that you mentioned Germany as one particular market with wanting to do what they can about legislation, and also fascinating about, in addition to GDPR, which is sweeping some of the national legislation. Why don't we go to the UK now with Bryony, because you might have maybe a little bit of a different perspective of GDPR. I mean, I know obviously that it is the same across all markets, but let's hear what you have to say, Bryony.
Yeah, so like with all member states, though obviously in the UK not being a member state anymore, all the GDPR was implemented into local jurisdiction. So in the UK, that was the UK Data Protection Act, and of course, while it's predominantly based on the principles of the GDPR, there are a few differences between, say, UK law and German law and other European state law. However, from a marketing perspective, the principles are broadly aligned. The other piece of legislation that I think is important to mention as well from a marketing perspective is the PEC regulations, or short form the PEC regulations, but the Privacy and Electronic Communications regulations, which come from the e-privacy directive, which is again a European directive, and all member states will have implemented that. The UK, as I say, implemented it in the form of the Privacy and Electronic Communications regulations, and those are the regulations that require you to obtain consent for cookies and obtain consent to send electronic marketing. And although that law hasn't changed, the introduction of the GDPR has had an impact on how that law is interpreted, because now the requirements for consent have massively increased. So we have seen a change of approach by our regulator as a result of now the higher bar of consent and what good consent looks like. So despite the fact that the law hasn't necessarily changed, the regulator is now regulating it in quite a different way, and I have to say, in a way that probably isn't quite as pragmatic as it usually has been in the past, which has obviously made marketers have to sort of step up their compliance in the UK.
Yes, it sounds like this is certainly a playing field that is changing all the time, and the difficulties that marketers have staying up to date, particularly as some things are implemented and then other things are added, does make it complicated. Now, let's take a look at another region just very briefly now. Oscar, why don't you talk a little bit about South America? And I know that you've mentioned some things about Brazil in the context of their business with Europe. So I'm sure all of this does play into the whole global marketing issue.
Exactly. Thank you. Well, I would like to start that it's interesting because South America tends to be perceived as a single unit, as a single distinct unit, but in reality it's quite diverse. And so you have, on the one hand, jurisdictions which are very sophisticated and have a comprehensive law and an effective authority which monitors the enforcement of that law. And on the other hand, you have the other extreme countries where there isn't really a privacy law or a data privacy law as we understand it to be. But what's interesting is that those countries that do not have a law or don't have a law that's really as developed, they're all moving forwards to copying or inspiring to have a law that's similar to the GDPR. So in that sense, what my European colleagues are saying today, it's quite applicable, or will be very applicable to the actual South American reality. And in that sense, I think it's important to note a few examples of countries which are moving forward in that direction. I think most notably Brazil. They recently enacted their own data privacy law. And it's very similar in many ways to the GDPR in terms of fines, in terms of extraterritorial application. And what's interesting in the case of Brazil is that they have authorities which are not shy about imposing fines and laws and enforcing this specific sanctions, and when their laws are not being followed. And in that sense, I think from a South American point of view, I could say safely that the most sophisticated legislations and systems in data privacy are located in Uruguay, Argentina, which are adequate countries for the European Union. And Colombia also has a very sophisticated and authority that issues regular guidance on data privacy. So that's something that marketers need to know. The continent is diverse, and they will need to focus specifically on the country depending on their needs.
Oh, thank you. That makes a lot of sense. And I'm sure if they are doing some business there, they just recognize how vastly different the continent is. But it seems, obviously legally as well. Let's just switch to another topic for a minute. Daniel, I believe that you've been quoted as saying privacy compliance has shifted from a business best practice to a business necessity. Now, I'm wondering if that also means that privacy will become a competitive differentiator among brands. Can you start by talking a little bit more about this?
Yeah, I think that's exactly right, Deborah. So I think back to when I first started practicing in privacy law, and I went to a privacy conference, and there were a bunch of seminars, and one seminar was all about how to explain to the C-suite the value of privacy. And I can't tell you how tough it was to explain, to put it into a monetization, to explain look, here is the actual value add that you have to the company. It was more feely, but that's really changed, especially in the United States in the last several years. And as Oscar just was saying, in South America and in other jurisdictions, where what you've seen now is so specifically in the United States, laws now that are very, very comprehensive, and laws that impose harsh penalties on companies for failure to comply with privacy law. So there have always been, and there's been for a long time now, privacy laws, and which could be enforced by regulators for being an unfair or deceptive act or practice. And there have been specific privacy laws, for example, the Telephone Consumer Protection Act around text messaging or calls, which have very high penalties. But with respect to just general data use and rights, we really haven't had that much in the United States. And so now with the California Consumer Privacy Act, you're seeing very, very robust penalties and regulators that are indicating that they are serious about this and that they intend and that it will have an underlying impact on the company. And GDPR is also a great example of that. And I'll let my colleagues here talk more about that. But another issue is around extra jurisdictional authority. So everything is going online with respect to globalization. And it's really tough to keep somebody who is in Europe from visiting your US-based website. And regulators take the position that if you're going to be collecting data from individuals located in Europe, for example, or vice versa, if you're in Europe and you're collecting data from California residents, those individuals have rights. So there's this issue around how do you address obligations worldwide and making sure that you are compliant. And it's really, really tough. So this is absolutely something that companies need to be very cognizant about because it has very real implications.
I'm sure, and I know that is one of their largest worries right now. Before we get to Europe, let me just jump right back to Oscar, because you mentioned 3 countries that did seem to have pretty stringent rules. I believe you said Uruguay, Argentina, and Colombia. Do you want to talk a little bit about that before we go back to Germany and the UK?
Yeah, sure. And I'll like to connect that to what Daniel just said, in the sense that it's also a business necessity, privacy, not only from a legal point of view, but a business sense of it. And in our continent, and I'm sure in all those countries as well that you mentioned, Uruguay, Argentina, and Colombia, there's a reputational aspect to it, in the sense that even if your laws are not that strict or that comprehensive, at the end of the day, your consumers will punish you if you don't take privacy seriously. And that is something that I've been seeing here in Chile and in neighboring countries, in which companies are not only afraid of a potential authority that might sanction you, but they're also afraid of the market, in a way, how the market will affect your business and your reputation if you don't take privacy seriously. And in that sense, I would just like to make a quick connection to the fact that even in those countries in which perhaps the legislation is not as sophisticated as the European or the California one, it's interesting how companies are still obliged to comply with those rules if they wish to become a vendor to those companies, to contract with a European company or even an American one that is subject to the GDPR or to some other important privacy law. And so in a way, there is a conversion towards the higher standard in law.
It's interesting, and thank you for bringing it back to the issue of, is it a business best practice? It's become a business necessity. I was fascinated by what you said about consumers will punish you. Now, Bryony, you've talked a bit about how, let's not forget that consumer compliance and choice is something good. So why don't we just get your take on this, again, this issue of moving from best practice to business necessity and what that means to consumers.
Yeah, absolutely. I think that one of the underlying principles of the GDPR is giving consumers control and choice over how their data is used, and consumers now expect that. And so when marketers are looking at their compliance profile, at the absolute forefront has to be the consumer's best interest and what the consumer would want. And therefore, if you are engaging in practices which a consumer might find creepy, or a consumer isn't aware of what you're doing, then those are the kind of practices that nowadays are just not going to be GDPR compliant, and they're not going to be consumer friendly. And I think that, with a lot of my clients who have found particularly the challenges around getting good consent, and the impact that that's had on their ability to collect data and use data and dissect it in funky, cool ways, they find all that a huge challenge. And I've always said to them that actually the best data is going to be the data that people are giving you because they want to give it to you and because they know why they're giving it to you. And it's the same, when you're sending marketing communications, the people who have actually given their obvious consent to that communication are the people that are most likely going to interact with that marketing communication and are most likely to have success with it. So for me, albeit we've had to have a change of perspective in how we look at compliance, I actually do think that if you put the consumer at the forefront of your mind and give them the choice and them the control, I think it naturally will lead to better marketing campaigns and more successful results. So I think it's not just a business necessity. I think you want to be doing it from a marketing campaigning necessity as well.
Yeah, and I think that marketers are now getting a little bit more used to recognizing that everything they do, they have to give control over to the consumers, and it is the consumers who they serve. Soren, back in Germany now, do you have some comment on that in terms of what you are seeing in Europe?
Yes, data protection has definitely become more than just a best practice. But I would not restrict it to Germany. And when talking about the interesting fact that based on the law, the consumers are now vested with so much control on how their personal data is being processed, it seems also that the data protection has shifted not only to a business necessity, but also to a legal necessity. And while the business necessity might motivate companies to gain consumers' trust when being asked to hand over their personal data, I would just like to give 3 examples for a rather legal necessity. First, there is a data subject's right to claim information from the processor as well as correction and deletion of its personal data. Second, there can be cease and desist claims by competitors or consumer protection associations against processors if they don't comply with the law. And third, there can be very high fines of up to 20 million euros for a single violation. So you may find that compliance is a combination of business necessity and legal necessity, considering that the consumers now can have more control of their data, also by the permanent threat that they could report violations to the authorities.
Interesting. Well, let's look at another question before we get a little bit more theoretical. But what legislative trends are you all starting to see worldwide, or particularly among regions? Oscar, I know you've talked a little bit about how different the Latin American region is, but do you want to just quickly mention if you're seeing any particular trends that marketers should be on the lookout for?
Yeah, sure. As noted before, countries are adopting some sort of variation of the GDPR model, the European model. In that sense, the tendency is always to provide more notice and more choice to consumers, and we come from a paradigm or a standard in which notice and choice wasn't really there in the strength and weight that it should be. And now I feel and I see in the continent that the push is to have people better informed, more swifter, in the sense that they have a decision to make very close to the actual moment of collecting that information. And I think that trend will continue in that sense. And I think that's something marketers should take into consideration. If I want to process or collect data to do a campaign in South America, I need to think very deeply about how I'm going to give notice and choice to each of my potential clients, and how can I do that better.
All right. Anyone else have anything to add on trends before we get a little bit more theoretical?
So I'll jump in here. In the foreword of the book, we actually wrote about some of the very big trends that we've seen, looking at the 70 different countries and what the laws are respectively. And what Oscar said, he nailed it. That's exactly right. You're seeing increasing obligations with respect to privacy. A really interesting one I do want to bring up specifically for marketers or advertisers is around this concept of anonymized data sets, where you see, the term that is thrown around in the industry is, oh, we are working with anonymized data sets. We're taking certain types of data and hashing it or transforming it from one thing into another, and therefore it can't identify anybody. And I think a really big takeaway here is that is not what the law says. The law says that there are certain types of data sets that we would have seen, as an industry, as anonymized, which the law says is actually not. It's either considered de-identified or pseudo-anonymized, both of which have obligations under the law. Specifically, GDPR actually calls out obligations with respect to the data sets. So again, just something to note, that just because the nomenclature within the industry says one thing, it doesn't necessarily represent what the law says.
No, interesting. That is, I know that is a real issue. Any other trends that anyone's noticing right now, or should we jump to another question?
What Daniel just said about the anonymized data sets, this brings us to a point where we should also consider these data as a value. And I think this is very important in terms of future legislation, because this will, and in parts already have, become a driving force for the legislators to protect this good as a commercial value, first of the data subject, and then of the processors that have obtained legally. But coming back to your original question, whether we see similar trends in other regions, I would like to have a look at Europe again, at the European Union, because I think that the EU as a supranational entity is quite unique in the world. All other countries may cooperate or bind themselves by treaties, but there's nothing like the European Union, in favor of which the member states have given up such a great part of their legislative sovereignty. Although we see such supranational elements also in other organizations like the African Union or Association of Southeast Asian Nations, ASEAN, but to my knowledge at least, ASEAN does not have the power to pass laws which are immediately binding their member states. So other nations will have to really cooperate in order to at least harmonize their different laws in order to facilitate international trade, which always includes international data transfer. However, we did see some changes in parts of the world. The reason is that GDPR does not only apply to EU data processors, but is affecting processing and thus marketeers and brand owners in other countries of the world. GDPR applies to all processing of personal data of data subjects in the Union, regardless where the controller or processor is established in the Union, as far as the processing activities are related to the offering of goods or services to such data subjects in the Union. So this has led to many legislators of non-EU countries to thinking about adopting at least some of the rules of the GDPR. In order to help the companies established in their own jurisdictions to be able to do business internationally without violation of the GDPR or the other countries' national laws, there will be a trend to pass at least similar laws which take into consideration the implications of the GDPR for companies, even outside the EU.
That's a very important point, because I had always thought that if a U.S. company had an office in Europe, it applied to them. But it sounds like it's even much broader than that. Do you care to comment, or Bryony, do you have something to say on it?
Indeed. It is not only the EU office or affiliate of a US company, but also the company in the US that will be subject to the GDPR, provided that the EU office or affiliate transfers the data to the US company in the US for processing. But even if a citizen of the EU is just entering data on a website of a US company, for example, when booking a hotel in the US, the GDPR will apply because the US hotel is processing the data of a data subject in the EU.
Yes. Yeah. Would you like to say anything on that, Bryony, since we've now got everyone weighing in on it? Go ahead.
Yeah, I mean, I think, to be honest, it's been articulated already, so there's not much more to add. I mean, I think that Zoran does make a really good point in the fact that actually the GDPR's extraterritorial effect means that relatively few countries are now left untouched by GDPR. I think also, one of the requirements of GDPR is that when you're transferring data outside of the EEA, you can only transfer data to countries that are considered adequate by the EU Commission, and those countries are going to be countries that have laws akin to GDPR. So, I think that in order for this free flow of data, which has got to happen, and although that there are transfer mechanisms in place, albeit as of tomorrow we're going to find out if one of them is going to be invalidated. But it will be much easier if everyone's on a similar level of compliance, and then that free flow of data can happen much more easily. At the moment, there are problems. So, I do think that there's a sort of tidal wave of change going on. It started with the GDPR. As I say, the US and Brazil seem to have taken it up and gone even further with it. But it will the whole world will end up with a legislation that is akin to the GDPR. I mean, I was doing a talk. Slightly randomly, I guess, a couple of weeks ago to Nigerian business leaders, and Nigeria have just introduced a law which is incredibly similar to the GDPR. So it's across the whole world. So I think that we'll all have a very similar standard of compliance by the end of it.
That's interesting. Yeah. Go ahead.
Yeah, I just wanted to bring up something interesting that is actually a reaction to what Bryony is talking about here. Are laws centering around data localization. So countries that are saying you cannot actually export the data out of our country either period or without certain types of safeguards. And I think, Europe doesn't specifically fall into that, but Europe does say that if you're going to be handling data from individuals who, have rights under GDPR, you have to enter into these contracts, standard contractual clauses, or some type of other mechanism. You have many other jurisdictions, for example, Russia, that say if you're going to be processing data, it has to stay within Russian borders. So there's this really interesting response right now that's this pushback saying, we want to make sure that the obligations of our country and the laws there are followed very, very closely, and therefore it cannot leave. And so we're going to continue seeing that. I wouldn't be surprised if down the line, US has something similar to that. It's just something that marketers really need to be thinking about with respect to campaigns.
No, good point. And I realize now that despite all of these concerns about privacy, data-led marketing is obviously here to stay. There's no question about that. It sounds like the bigger issue, as we talk more theoretically, is really how do brands build trust with consumers? Or are we getting it wrong, or at least the wrong way around? Is that I know that Bryony mentioned earlier that consumer choice and consumer protection is a good thing. But let's now talk a little bit about how you insert the brands into it. Who wants to start on that one?
I'm happy to jump in. Bryony used a very technical legal term before that I love called creepy, right? Don't be creepy. and it shouldn't be. I mean, it actually isn't a term, but it should be a term. But to me, that's kind of like a baseline test. What you're thinking about doing creepy? Like, should you be doing this? And in the US, we have this concept of the reasonable expectation of the consumer. Would a consumer reasonably expect what you're doing with their data? And if not, right, you really have to be thinking about, should you be doing this? Because even if it's not specifically prohibited by the law, it could be deemed to be an unfair or deceptive practice under the law. So that is, to me, that is such a essential thing for businesses to be thinking about at the beginning. Is if it was happening to you, like, would you feel comfortable with this being put into the shoes of the average consumer?
Yeah, and I'm sure that varies by category. I mean, obviously, if you're, pharmaceuticals might have, one standard versus alcoholic beverages, but, as one example. Anything else on trust? Because if not, I'd like to talk a little bit about privacy and personalization and third-party cookies.
I guess I'd just add one thing on trust. I think that being a good data protection citizen now is a must, and I think we've talked about that earlier in terms of a business necessity. But I think that marketers and advertisers now really need to be using that to their benefit and using it as part of their campaigns and persuading people that actually having ads targeted at you is a good thing. Trying to make sure that they know who their customers are so that they can send them more tailored offers is a good thing. So I really do think that there is a way for brands and marketers to build that trust. But I think it all does start with fundamentals. We will look after your data. We won't do anything creepy. We will be open and transparent and upfront with you, and we won't do anything without your consent, and you have control. But actually, all those things aside, if I'm data protection lawyer, I like targeted advertising. I don't want to get stuff on my internet browser which is stuff that's completely irrelevant to me. I want stuff that I want to be interested in. I'm a sucker for ads. So for me, if someone explains that, okay, in order to do that I need to use your data in this particular way, but I'm going to do it in a way that's compliant, I'm going to do it in a way that meets the standards that you would expect, I think people would be happy about it, and people would allow you to do that and give you the control to do that. So I think there's a huge education exercise, and funny enough, I won't touch too much because there's a separate point I want to raise around the personalisation point, which I think we're going to come on to. But I think that there is a big campaign here, and if we get it right, I think that there are ways that the brands can build that trust in a compliant way and not have to do creepy, underhand ways, things to use people's data. So.
Well, why don't you continue on that? Because obviously it's clear that you do believe that privacy and personalization can certainly coexist.
Yes.
And why don't you talk a little bit about that? And then I know that we all have some things that we'd like to say about the crumbling of the cookie. So.
Yeah, absolutely. I mean, I think that, I actually work across the spectrum. So I work with a lot of brands, a lot of agencies, a lot of ad tech vendors, and a lot of publishers. And, personalization and using data in that kind of way is absolutely key to all of them. The fact that these third-party cookies are going to, see the end of it, and everyone's going to have to completely reshift their perspective. It is going to be a big change for the industry, and it's not an easy problem to solve. But I think maybe I'm being naive, but I think that the way that one tries to solve it is to explain to people the benefits of it. And there was the most fantastic campaign when GDPR came out about what GDPR is all about and why you need to comply and why you need to be scared of it. It really encouraged compliance and it really encouraged people to change their ways. And I really think that if you can get that kind of campaign up and running as to why having cookies on you are good. If there are certain people who don't want to have ads personalised at them, or they don't want personalised experience, and that's fine. And if they don't, they can choose not to have it. But there are people that do like it, and I think trying to think of ways to encourage them to opt in, which is obviously going to be the way forward now, it is a good thing. And I think that again, it's about a bigger campaign, and I think that's something as an industry we have to work together to try and get that campaign up and running and encourage people that actually we're not going to misuse your data. We're not going to sell it to someone that we shouldn't be. We're going to use it for your benefit. And I think that once you get that message across, hopefully the impact that is no doubt going to come down the line with not having not being able to, or having to get opt-in consent for cookies, which to be honest, arguably we have to do now. Well, not arguably, we do have to do that now anyway. But that consent process is going to be much more. At the moment, we get a choice of opting in. What they're talking about is having to go into your browser settings and select stuff, which no one's going to do because it's going to take time out of their busy days. But if we can try and have a general campaign about it, I think that we might find this isn't quite the big large scale problem that it's currently sort of tends to be.
So just quick question, just a quick aside, who funded the GDPR campaign? Was it the government itself?
I have to say, I'm not entirely sure. Sorry, Mike. No, I think it was just a general, or by the regulators and just general publicity. I whoever did it did a marvelous job, because it got everyone talking about it, and a lot of work came our way as a result. So, but yeah, I don't think it was one particular organisation that funded it. I think it was just a general. It was industry led.
It's a very smart way to approach things. Oscar, let me just go to
Deborah,
you then. Yeah, go ahead. Go ahead.
I want to contrast that with what happened under California law, right? And so the way we got to where we are right now with this California law, it was actually funded by an individual, by a man named Alistair McTaggart, who pushed forward an initiative to create a law. And the law, I like to call it a Frankenstein. It's kind of a combination of GDPR as well as, proposals that previously had happened. And the big issue with the law is that unlike the GDPR that went through many iterations with stakeholders, the CCPA really doesn't have that in line. And so the way that the law is written is very, very difficult to comply with, because it wasn't drafted by somebody who has the fundamental understandings of the ad tech industry, which I think is a large aim of the law to be able to curtail that. And part of that is in response to a lack of transparency. Going back to these concepts, right, about notice and choice, is that there is this use of data, it gets taken, and somehow or other there's an output where you get personalized advertising. Like, how does that work? And so it's not so much that I think individuals don't like the end result, it's the issue around the lack of transparency. So we as an industry have an obligation, this is how I look at it, to ensure more transparency, to describe how the processes work. I don't think personalization is going anywhere, but it is important for us to be so clear about that, because if that doesn't happen, you get the result of people being involved with measures to change law here that really don't understand the concepts of how the technology works. And then you get full out prohibition. And the concern with that is that full out prohibition fundamentally impacts around monetization, right? Within how do companies stay alive? So much of monetization is based off of advertising and the freedom of that. Otherwise, what you're going to see is subscription-based models, and you're going to see only companies that have large numbers of subscribers who have huge first-party data sets be able to actually exist. So if anything, it becomes more anti-competition. And so that's the fundamental issue that I think we need to all be fighting for here, is to ensure that there is continued ability to do personalization within the scope of addressing and ensuring privacy.
Deborah, if I may jump in, it's very interesting what Daniel's saying, in the sense that at the end of the day, it's about transparency and knowing how the technology works and making sure the consumer understands that. In that sense, in connecting to the previous question and the cookies, the crumbling of the third-party cookie model in a way, I think trust really goes beyond the technology that you're using in a certain point of time, in any given moment in time. And in that sense, the leaving behind of the third-party cookie, I think the writing was on the wall in the sense that there have been quite a few browsers that have blocked by default the use of third-party cookies. People and consumers understand now a lot better how third-party cookies work. Wasn't so the case in 20 years ago when the internet wasn't as massive as it is today. So I think for marketers, and I think that would be kind of my advice, or my advice would be to put attention to this, that if tomorrow or in the near future you won't be able to use third-party cookies as you were used to, I think perhaps that personalization will shift perhaps to other technologies. For example, as the software development kits, then that's something that has extensively talked about before in other venues. So at the end of the day, personalization will not go away. I completely agree with that with Daniel, but it will probably be shifting to different technologies and different ways of doing it. So perhaps today, the third-party cookie will eventually fade out or will start to be less used. But there will be other ways of doing that personalization. And what's important is that lawyers, such as us, need to explain to our clients, to consumers, to whoever we're advising, how that works and what are the implications of the use of that technology in any given time.
Oh, interesting. And I guess that's a little bit of the difference between, third-party data and first-party data. And I've even heard terms of zero-party data, which is probably more semantics than anything else. Any other thoughts on that?
Maybe just as a closing remark about the crumbling of the third-party cookie. Of course, Oscar is right in saying that doing away with the third-party cookie does not mean the end of personalization. But on the other hand, you all have probably heard about a recent judgment of the ECJ and the German Federal Supreme Court, according to which website operators are required to seek consumers' consent for each cookie. I believe that consumers will be very relieved if they do not have to click away the annoying cookie bar anymore. And website operators will be happy because they do not have to include a rather complicated privacy policy for each third-party cookie they are using. Impact on privacy? Yes, because the fewer data are being collected, the data will be used.
No, you're absolutely right. Interesting. All right, let me go to something else that is a bit conceptual here. Okay, according to a Mighty Hive survey of 200 senior brand marketers, less than 1 in 20 said they believe that they are tapping into more than 80% of their potential first-party data. So again, that's less than 1 in 20 believe that they're tapping into more than 80% of their potential first-party data. However, there's always a bright side to these surveys. However, 67% think that they will get there in terms of getting up to 80% by the end of 2021. I'd love to hear some comments on this, and I'd like to start with Daniel, because I believe that you've called this data minimization, and you feel rather strongly about when data is collected, you should also use it. So would you like to talk a little bit more about that?
Yeah, I think this whole concept about first-party data, we're just at the brink of it right now, and it is going to become a huge area in the next few years, especially with, as we're saying, the crumbling of the cookie here. So specifically under GDPR, there is this concept of data minimization, right? You're only supposed to collect as much data as you need for the purpose of facilitating the service. And also California law may be going that direction in the not too distant future. So the idea here, what I understand from this question, right, is that you have marketers who are going, hey, we have all this data and we're just collecting it. Maybe we will then take that data and use it for other purposes. And I get this type of question all the time from the agency clients that I work with, and advertisers. And this is just it's something that you should be really careful about, because with more data means more obligations under the law. If you have more data sets, it's more likely you're going to suffer a data breach. If you have more data sets, you have to be more concerned around the notice and choice that you give to users and that you make sure that you're complying with the obligations. So again, just really, really important to be thinking about when you're getting these data sets and using them, what it's going to mean down the line. First-party data, we're going to see what happens here with it, because I think that there's a lot of potential uses, and you might see things very similar to kind of like a Facebook custom audiences where it's used for matching purposes. I've seen a number of clients or other companies as well that have been engaging in types of data matching where they're taking first-party data and then matching it against like a live ramp or another party to actually allow advertising on their own platforms now. So it's really interesting where we're going, because that's where I think kind of the next wave of personalization is going to be.
May I jump in? I would just like to reinforce the idea that Daniel just has stated, and I would like to repeat a very cheesy phrase, but I think it really brings home the idea of what's behind data minimization. Is that at the end of the day, data doesn't age like wine; it ages like milk. So it won't get better. The data at the end of the day won't get better with time. It only creates liability. Perhaps you will never use it. So try to get rid of that data, because at the end of the day, we might hurt you.
Interesting. I don't think we'll forget that one. See, that's the beauty of advertising and marketing. You come up with something like that, and you don't forget it, right? All right. Well, we've been talking for quite a while now. Let's close out with an important last question to everyone, and let's take a look at 2 years out or 5 years out. What's ahead for privacy legislation, and particularly in light of what's happened now with COVID-19? Will there be a push towards some uniformity worldwide? Will there be more state-by-state issues within the U.S. or things that I haven't even thought about? Let's go through with everyone. Who would like to start? And then we'll just go through the whole group.
I mean, it's a difficult one. I mean, who knows exactly what's going to happen in 5 years' time? I think that the obvious thing that's going to happen is that there is going to be more uniformity around the laws. I don't think there would ever be one law that governs all, because of the fact that we've seen in Europe alone, even with the GDPR, which was meant to harmonise the law across Europe, the regulators all have a very different take on what the law is, and there is still a lot of work to be done on that harmonisation, as they call it. But I think that from a marketing perspective, I think that the introduction of the e-privacy regulation, when that finally decides to make an appearance, will be quite a game changer. I think not just because of the fact that it's introducing more stringent rules around cookies and metadata, but it's narrowing the soft opt-in, which a lot of marketers rely on, and it's also suggesting that you would need consent. Is a B2B marketing, which is going to be a real game changer for everybody, because if people like me rely on legitimate interest, and that's not going to be something going forward. We're going to have to get consent, and that's going to be difficult. So I think there are a few changes on the near horizon. I also suspect that there will be more. Interestingly, obviously, the difference between European law and US law is a sort of sectorial approach to law. At the moment, we don't have that in Europe. I mean, we obviously have different sector guidances and that kind of thing, but we don't actually have as many sector-specific laws as, say, they do in the US. And I think that might change. I think we might get more specific laws around certain sectors. Certainly, we'll get, in Europe, they're looking at a lot of certification schemes. And I think that even if they're not laws, if you want to sign up to these certification schemes, you're going to have to comply with their requirements, and they will be sector specific. So I think that we'll be seeing more of that on the horizon.
Great. Why don't we go to you, Soren?
Generally, the GDPR contains already a set of very comprehensive rules, which would probably not need to be amended. Not even in the light of COVID, which did have an impact also on the application of GDPR. However, as far as the still pending draft of the privacy regulation is concerned, COVID has actually given the draft a new push. Since Germany has taken over the presidency of the EU Council earlier in July, Germany suggested further amendments of the current draft, taking into account some issues that arose recently, probably also prompted by the talk and introduction of the technologies and structures of the various COVID tracing apps that are being introduced in several countries. But apart from the e-privacy regulation, which might get a push through COVID, and perhaps a few non-binding guidelines from industry associations and sector-specific certification requirements, I do not anticipate much of a change of privacy laws in the EU and Germany. Instead, I would expect a greater sensitivity and perhaps even acceptance for the already existing law. Just one example. After the end of the lockdown and the reopening of restaurants, etc., people are obliged to leave their personal contact data in many places, such as restaurants, hotels, hairdressers, and many other establishments where people gather. While the customers might accept that this might be necessary to fight the spreading of the virus and thus will most likely and deliberately provide their contact details, they will, on the other hand, also want to be very sure that the protection of their personal data is secured. So this does not only create a greater acceptance, but also a bigger expectation on the data processors and to treat the personal data with greater care. On the other hand, people working in any of the above fields face new challenges. The only good thing about this is, whether you like it or not, that GDPR has the answers. It's just that there's a lot of work out there for the processors to comply with it.
Well, you're absolutely right, and the COVID situation really makes this issue about data and personal data protection, I think, all the more intense and all the more worrisome. Oscar, let's go to you and see what you think is ahead, whether that's 2 years or 5 years, and also with COVID.
Sure. I just would like to take this opportunity to also to invite the listeners to read the privacy book that GALA has issued. I think there's a lot of material where you can actually look and comment on a specific country jurisdiction, but also on the big trends that we're commenting now. So I think that's a good step. Personally, I see quite a few trends. The first one is obviously, as we said before, conversion, in the sense that at the end of the day, most countries will have similar laws, or at least very similar principles, or exactly the same principles that will take effect in a specific way in its jurisdiction. On the other hand, I also see a big trend on having data be an increasing issue, not only in terms of marketing or strictly privacy issues, but also in other issues, for example, competition. Consumer protection. Those things they're very important cases being reviewed, but I think that trend will only increase in time. And at the end of the day, whatever field of the economy you're involved in, data and privacy will be an issue that you will have to consider. And finally, I think I see that there's also a push for to be more transparent and be more forthcoming with consumers in the sense of what you're doing with the data, and what is the expected outcome of that use. And in that sense, the things that we've been talking about today, about the fading out of third-party cookie use, I think it's a symptom of that, moving towards more trust towards the economy and towards consumers.
Yeah, well said. And now let's get a final word from Daniel in the U.S.
Yeah, so I agree with what everybody else has said here. I think it's spot on. Privacy law, in my mind, is reactionary because technology moves really, really quickly, and then you see the laws try to respond. And so what we haven't really talked about today, but is so important, at least in the context of U.S. privacy law, was the Facebook Cambridge Analytica incident of 2018, which I think really fundamentally changed the perceptions and understanding of some of the risks around lots of data and how that can be misused. And I think we're going to see something similar with COVID. This is my prediction, that we have large amounts of data that are being collected for contact tracing purposes, and most of these purposes are really great and beneficial. But in the US, this type of data collection is not really specifically regulated. So I mentioned HIPAA before with respect to health information. That's only in certain contexts and by certain types of entities. So I think there will be a reaction. I don't know when it'll be. Could be 6 months, could be a year, could be 2 years. There's already been proposed measures at a federal level to regulate certain types of health data. But I think that will gain a lot of traction over time. With respect to laws coming down the pipeline immediately, so we've talked a lot about the CCPA. There's this new proposal, the California Privacy Rights Act, the CPRA, which would be an amendment to California's law and actually add obligations to the CCPA. That's going to be a bill that's going to be in the November election this year, 2020, and I think it's very likely to pass. And if that passes, there will be a number of obligations added, and that will essentially be the baseline for U.S. privacy law. So again, lots of stuff to be thinking about. I think that privacy will continue to be a very fundamental part of organizations in terms of what they have to do for, compliance and ensuring that they, use data properly.
Yeah, well said. And I can't thank you all enough. You're all so passionate about the kind of work that you do, and you've also enlightened us on several sides of the issue that I don't think that we've all sat down long enough to think about. I would just like to say that, again, there's a lot of topics here, and there's topics that we haven't gotten to. So if anyone finds that they have questions on a particular concern, please let us know, and we'll plan upcoming talks focused much more specifically on some of those issues. So I thank everyone for participating, and I also thank everyone for listening.